Okay, welcome to the Great Estate Podcast. I'm your host, Chris Brown from the law firm of Eckell Sparks here in beautiful Media, Pennsylvania and Delaware County. I'm joined today by my colleague, Michael Davey. Mike is one of our litigators, and he has an emphasis on employment law. Amid the pandemic, there have been a lot of calls and a lot of people losing their jobs and having issues with returning to work. I know Pennsylvania and most of the counties returned to the green phase of the reopening as of today, as we record on the 26th of June, 2020. And I have a whole list of questions for Mike that I hope, well, I guess I hope they don't apply to you, but if they do, I hope you can get some good information out of this. And certainly, if you want to talk with myself or Mike, you can reach us at 610-565-3700. My email address is cbrown@eckellsparks.com. Mike's address is mdavey@eckellsparks.com. You can find that all at www.eckellsparks.com. Mike, thanks for joining me this morning.
You're welcome. Thanks for having me on. I'm excited.
Yeah, thanks for setting me up with my video too. This will be, hopefully, if I upload it correctly, our first video recorded podcast. So I'm pretty psyched about that. I've been doing recordings, informally for years now, and I never actually got the camera involved. So I'm pumped about that. So I appreciate it, man.
You're welcome. It's Happy Green Day. We're
yeah,
green
Happy
now.
Green Day.
Right? We're green. Should have worn my green tie today.
I should have like an intro with a Green Day song.
That's right. Hey, you know what? Lost opportunity.
Yeah, well, we could. I'll talk to my editor. But anyway,
do it in post.
Yeah, exactly. So, Mike, I want to jump right in because I don't want to waste anybody's time, especially yours. All right. So, can an employer take an employee's temperature before work? I know part of a lot of reopening plans involve things of that nature, and we're frankly fielding a lot of questions, and it's very odd to have your temperature taken before you enter anywhere, let alone your place of employment every single day.
It is. I mean, under normal circumstances, it would not be legally permissible for an employer to take employees' temperatures every time they come to work. But in the middle of the COVID pandemic, the CDC and the Equal Employment Opportunity Commission, which is the federal agency that administers and enforces the Americans with Disabilities Act, have all taken the position that it is legally permissible to take employees' temperatures given the potential health risks that are attendant to people being in the workplace who are potentially COVID positive. Although the EOC does caution people that individuals can have COVID without having a fever. So just taking a temperature in and of itself isn't the sort of the end all and be all of screening employees when they are entering or coming into a place of work.
Okay, so Mike, I know you and I are both part of the coronavirus task force here at our office. So, I mean, we've been intimately involved in creating a plan of safety for our clients and our employees, our attorneys and staff and paralegals. That was something that we had to consider, and it's just something that's becoming commonplace as we navigate this situation. So, I appreciate the background there. Mike, can an employee lose her job if she is staying home to care for a seriously ill family member with coronavirus?
Well, the answer is it depends. There's a couple different laws that sort of intersect here. There's the let me go backwards a second. So under normal circumstances, and I keep using that phrase, and we are definitely in abnormal conditions right now, but there's a law that's called the Family Medical Leave Act, which normally applies to employers with 50 or more employees. And that law says that if you work for an employer for more than a year and you have more than 1,250 hours of service, and there's 50 or more employees who are, generally speaking, in the place where you work, you're entitled to up to 12 weeks of family medical leave per year, which is unpaid leave, for a variety of different reasons. The most common is maternity leave, paternity leave. But one of the qualifying conditions normally is caring for an immediate family member who has a serious health condition. So if if an employee works for an employer that has 50 or more employees and their immediate family member comes down with COVID, um, they could theoretically apply for and take family medical leave to spend that time at home um, caring for that individual. Um, you also now at the end of March, beginning of April, Congress passed what's called the Families First um, Coronavirus Relief Aid Act. The FFCRA is what we call it, which did a couple things. And one of the things that it did was it created this new emergency sick leave that gave every employee who works for an employer with 500 people or less, who's been there for at least 30 days, 80 hours of paid sick leave for a variety of different reasons. One of them being caring for an individual who either has COVID or who's at home waiting to be tested for COVID or has been quarantined. And that 80 hours, so essentially 2 weeks of pay, is payable at either the individual's regular rate of pay or $511, whichever one is higher.
Okay.
So it's a pretty good incentive. And the law also says that an employee who's qualified for emergency sick leave can't be retaliated against for exercising any of their rights under the law. So I would say, generally speaking, if you're an employer and you have an employee that is taking time off to care for a family member, it's probably not a good idea just to terminate that individual. You definitely want to get some sound legal advice before you do that, before you accidentally walk backwards into a lawsuit.
So, I mean, is each situation going to be unique, or is it gonna be formulaic how you deal with these situations?
All of these situations are unique. All of them really are on a case-by-case basis. It depends on how large the employer is. It depends on whether the individual has taken any family medical leave in the last 12 months for some other reason, and do they have any time left? Do they have some sort of accrued vacation or sick benefits that can be used to sort of fill in any gaps? There's a lot of different sub issues that go into it. So it's a new law. I've seen no decisions or case law on it yet. We have some new regulations, so it's always a good idea for employers who are trying to navigate these waters to seek legal advice before pulling the trigger on things like this.
So, piggybacking off of that, you could certainly, we talked about the risks of losing your job for staying home to care for a loved one. Now, can an employer actually require an employee to come to work or come back to work? And what happens if the employee refuses?
Well, again, the answer is it depends in true lawyerly fashion. Um, if it's just a situation where there's nothing wrong with the employee, but the employee says, I'm subjectively not comfortable returning to work yet, and the employer says, but we need you to return to work, then I think, yes, an employer can require the employee to return. And if the employee says no, they can be terminated. Now, again, there's a lot of different iterations and variants to that. If an employee says, not just I'm subjectively not comfortable returning right now, but here's a doctor's note that says I have an underlying medical condition which makes me more susceptible to COVID, and my doctor's recommending I stay out on unpaid leave for another few weeks until this thing blows over. I think that would legitimately constitute a request for reasonable accommodations under the Americans with Disabilities Act, for which an employee can't be terminated for.
So you're speaking to like immunocompromised individuals as opposed to somebody who's like, just say, subjectively afraid of, of returning to the office or wherever their workplace is.
Correct. And that's an important distinction. I mean, just being subjectively afraid or fearful or anxious about returning to public or the workplace doesn't give you any special protections under the law right now. Obviously, if you have COVID, if you're being tested for COVID, if you're under a doctor's self-quarantine order because of some COVID-related reason, then you may be entitled to some protections under the law for which an employer can't force you to return to work for, I would say, at least 80 hours from the timing of or the date of that order or that request by the doctor. And again, if the reason for someone needing to stay out is not COVID itself, but some other health condition that makes that individual more susceptible to COVID, then it's just like any other disability type question where a request for reasonable accommodation, which can take the form of unpaid medical leave, is protected activity for which an employee can't be retaliated against for requesting.
Now,
So,
in law, there's the distinction between an actual employee and that of an independent contractor. Um, is there any distinction, or are there any benefits that an independent contractor can receive who find themselves out of work due to the coronavirus? I mean, I know a lot of people work remotely already, or they travel a lot for work, and they might be an independent contractor. That they might not run into the scenario where they have the big boss telling them to return to the office or whatever, and those scenarios you just described. But they're an independent contractor, and now they're out of work.
right. So again, I'll preface it. We'll go back to the normal times, the pre-COVID days. If you were an independent contractor and something happened and you lost all your business, or you lost a lot of contracts, or you find yourself out of work, there was really nowhere for you to go. I mean, you couldn't file for unemployment because you didn't work for anybody but yourself. As a self-employed individual under normal circumstances, you're not eligible for unemployment in Pennsylvania. One of those laws that I mentioned before that was passed by Congress was called the CARES Act. One of the things the CARES Act did was it created a brand new sort of a federal unemployment track out of thin air that was available specifically and only for individuals who were otherwise disqualified for benefits under a state unemployment system, like independent contractors,
Right.
like Uber drivers, Lyft drivers. So if that person finds themselves out of work now because of COVID, and there's a list of like 20 factors that you need to fit into one of those categories in order to be eligible it's called the Pandemic Unemployment Assistance Program. If you are an independent contractor and you can't get benefits through the Commonwealth of Pennsylvania unemployment system, you actually fill out a separate pandemic unemployment assistance application through the Pennsylvania Department of Labor and Industry's unemployment website. And if you're approved, and you should be, you get basically whatever benefits you would have gotten if you were an employee under the state system. They use the same calculus and the same numbers, plus the extra $600 a week in federal benefits that have been given to people on traditional state unemployment. So yeah, it's actually a very very robust system that was created. They had a little bit of trouble getting it off the ground because nobody was ready for it. But it does exist, and it exists through December 31st of this year.
Okay, unless it's extended or something along those lines.
Unless it's extended.
Mike, now we've been talking about being fearful or caring for someone else, but we haven't actually talked about getting the virus to a certain number of people. That's actually going to happen. And hospitalization and death risks aside, what if an employee becomes ill with COVID-19, the coronavirus, or is placed on an order of quarantine after their business reopens?
So again, if one of the qualifying events under the Families First Act, where an employee is entitled to that 80 hours of emergency sick time, is somebody who contracts COVID or is at home under a doctor's quarantine awaiting COVID results. So, there was a little bit of logic to this. The quarantining timeframes for people that either test positive or who are maybe in contact with somebody who was positive is 14 days, right? So, 2 weeks worth of work, those 2 weeks or 80 hours is going to get paid. That's sort of the logic. So if you have an employee who comes to you and says, either I've been tested positive, or my doctor ordered a test but is quarantining me while I await the results, those individuals are entitled to emergency sick leave under the Families First Act, which again, it's their the whatever the employee's regular rate of pay is, daily rate of pay, or $500 a day, whichever number is higher. The employer pays that money in the beginning, but any of those funds that the employer expends for that purpose, the employer can take a dollar for dollar tax credit from on their federal employment taxes, which is pretty good. So while the employer has to front the money, it ultimately is a net zero to the employer because they get the credit on the back end from the tax reporting. And again, because an employee has a right to those benefits, they can't be terminated or disciplined because they ask for it or because they're entitled to it. That would be textbook retaliation.
Okay. So something that I think maybe is hyper relevant to you and I in particular, because we both have some kids, and we're both, our kids are around the same age. And not to re-ask a question I already stated earlier, but now what if an employee has to take care of someone who's sick with COVID-19 after we reopen, or has to take care of a dependent child whose school is closed due to the coronavirus?
Yeah, so the first part of that, I think we already covered in terms of somebody who has to care for an immediate family member. But the second part we didn't talk about, which is what happens because of all the school closures. Now, fortunately, right now, sitting here today, it's June 26th, the schools are closed anyway, not because of COVID, because it's summertime. So
Right.
we don't have to worry about this right now. To some extent, we do a little bit because a lot of summer camps and daycare facilities still either aren't open or aren't open to full capacity. Um, the that Families First Act, in addition to the emergency sick leave, it also created, well, actually what it did was it amended the Family Medical Leave Act, which I talked about before, and added a new category of what will be determined qualifying leave for the purpose of the Family Medical Leave Act. And what it now says through the end of this year is that if an employee, again, who works for an employer with 500 employees or less, is unable to work or telework because they have to be at home caring for their child because their child's school or care facility has closed due to COVID, they're entitled to family medical leave, just like you would for maternity leave or paternity leave, up to 10 weeks at a pay rate of either 2/3 of their regular rate or $200 a day, whichever one is lower. So it's sort of the opposite of the emergency leave. The first 2 weeks of that, however, they're also entitled to or can be entitled to the emergency sick leave because caring for a child whose school is closed is also a qualifying factor under the emergency sick leave provision, which was $511 a day or the regular rate of pay, whichever one is higher. So it gets a little confusing and working out which pay is when, but there is now a 10-week pay leave provision essentially under which parents or guardians who need to care for children under the age of 18 because of a school closure, they have that ability. Now, the important and the significant part is that they created this by amending the Family Medical Leave Act. And the Family Medical Leave Act has in it normally, provisions that prohibit retaliation for exercising those rights. It provides for a right of reinstatement. When an employee's Family Medical Leave Act ends and they're able to return to work and perform all the essential functions of their job, Family Medical Leave Act says the employer has to bring them back, either at the same job or an equivalent job or a different job with equivalent pay and benefits. So I imagine, and again, I haven't seen any cases on it yet, but the way I read it and read the regulations, it says to me that that reinstatement right applies equally to somebody who is at home because they have to care for their child until the school reopens. Now, again, I don't think we're going to see a whole lot of this right now because most schools are closed anyway because of the summer, as I mentioned, but this is going to rear its head again come September,
Right.
when who knows what the schools are going to do. I think they hope they know what they're going to do, but if there's a surge, if things change, who knows. But the The family leave provisions for childcare also go to the end of this year right now, unless they're extended or amended somewhere down the
Right.
line.
Yeah. So that'll be something to continue to monitor, and it could be a firestorm of activity and questions and people requiring counsel, I guess, come the beginning of the fall, the end of the summer.
Definitely.
Um, so I've been speaking from the perspective of an employee, and like what my rights are, that of an independent contractor. To shift back to the focus of if I'm now the employer, it's my business. How much information can I, as the employer, request from an employee who calls in sick or tells me that they're awaiting the test from their doctor in order to protect the rest of the workforce? I mean, I'm not trying to be nosy, and I'm not trying to flush out people who are trying to play hooky or something like that. I want to protect the rest of my office, and I want to make sure that I'm gathering all the appropriate information. So now employee A has come to me and said, I've tested positive. We know what they're going to do. They're going to go quarantine. But now what do we do? How much information am I allowed to get from them?
I think, you're allowed as an employer to get whatever information you normally would be able to ask of an employee in terms of any sort of sickness or disability context, right? If someone says to you, I've been tested positive, I think as an employer, you're well within your rights to ask the employee, get me something from your doctor. Get me something from your doctor that says, this individual's been tested positive for COVID, just so there's a documentary trail. I don't think that the employers need to simply take an employee's word for it. Because if we're under normal circumstances, again, I use that phrase. If an employee called up and said, I'm unable to come to work because of X, Y, and Z medical condition, the employer would say, well, send us a doctor's note.
Right.
So I think that the same rule applies. If it's not a COVID test, if someone says, I'm not coming in today because I'm sick, well, I mean, the first question is the employer is, do you want the information? Do you need the information? And what difference, what does it make? Because if the person's coming in or calling and saying, I'm not coming in today, I'm not feeling well, then they're not in. So, you could ask, how long have you felt like that? Or, what symptoms do you have? Or do you have a cough? Do you have a runny nose? Do you have a fever? Do you have a dry cough? Basically, if any employer goes to the CDC website, you'll find a list of COVID-related symptoms. I believe any employer that gets a phone call from their employee that says, I'm sick, I'm not coming in, would be well within their rights to sort of ask the employees, do you have any of these symptoms? I don't think the employer, can, tell the employee or recommend the employee what to do in terms of going to a doctor or getting tested. But,
Yeah, that's actually my next question. Can employers require that an employee stays home if they have the symptoms, but maybe they're either being a tough guy and they're being stubborn and not going and getting tested, or they just haven't gotten around to it yet, or something's in the process of being scheduled? Can the employer send them home while the ball's sort of up in the air?
yeah, that's one of the tougher questions. And what I've been sort of advising employers is that what you should do is tell the employee who calls and says, I'm either sick or have all these symptoms, that they're not allowed to return to work until they're cleared to return by a physician, right? I mean, again, my general advice to employers is, unless you are a doctor, you're not a doctor. Don't play one on TV. You don't know, what is medically going on with the employee other than what they're subjectively telling you. So get something from a physician. If you have a note in hand from a physician that says, I've examined this person's my patient, this employee's my patient, this person has been tested for COVID, the employee is negative, I'm clearing this person to return to work. As an employer, at that point, I don't think you have any legal basis to say, I'm disagreeing with that, right? You're not, unless you are a doctor, don't be a doctor. Um, because if the doctor says they're medically cleared to return and they're not symptomatic, or they're not, um, able to transmit anything and not create a health and safety problem, I don't know that you have any grounds to say you're not allowed in.
Okay. Now, if somebody believes they were infected by COVID-19, so now that same employee, it turns out they did have coronavirus, they've tested positive for COVID-19. Should I direct any employees who believe they were infected by COVID-19 at the workplace to submit to workers' compensation claims?
That's an interestingly worded question. I mean, I don't know that I'd be necessarily advising employers that they should be affirmatively recommending that their employees file comp claims for COVID reasons. I mean, obviously,
Let me
if
change the
somebody,
question. When my uncle or someone calls me, and I'm the consigliere of the family, and they want to know what they should do, I got corona at work, and so wasn't wiping things down, and we got it. So what do I tell them to do? Should I say file a workers' comp claim? I know
yeah, see,
employers aren't
yeah,
going to say file a workers' comp claim.
no, I mean that's you're right. I mean, if somebody honestly believes that they contracted COVID at their place of employment, then absolutely they have a right to file for and seek workers' comp benefits, because that would be an occupational injury that would qualify them for benefits under the Workers' Compensation Act.
Yeah.
I don't know how they're going to prove it,
Okay.
but they're allowed to file for it.
Sure.
Now, as an employer, you know, you know, I don't know that you necessarily should be dissuading employees from filing comp claims when they believe they sustained an occupational injury. But unless it's patently obvious that somebody injured themselves in the course and scope of employment, I don't think that there's an obligation for the employer to affirmatively run around and tell employees to file comp claims. But if an employee honestly believes that they were at work and they got COVID because their employer wasn't doing what they're supposed to do, then yeah, they have a right to file a comp claim. It should go through the system, and a workers' comp judge at some point will make a finding.
Yeah, I imagine they'll be making a lot of findings and new ones, one way or the other. Just to get a bird's eye view real quick, because we were talking earlier, I think primarily about unemployment and like what you do, or quasi unemployment, while you're bridging the gap, getting over the illness or taking care of someone or taking care of your kids. I had kind of just switched gears to workers' compensation, just for like a lay person. What's the difference between unemployment and workers' comp?
All right, so we're talking about sort of three different things here. So the first thing that we've been talking about for the last 15, 20 minutes under the Families First Act is emergency sick leave pay. That's pay that you're entitled to as an active employee if you are quarantined, not able to, if you are tested positive with COVID or treating with a family member with COVID, or you're waiting COVID results, as an active but perhaps furloughed or perhaps not able to work immediately employee, you're entitled to that leave. If you're unemployed, you're not entitled to emergency sick leave anymore because you're not employed. Then if you're unemployed or you're furloughed, you transition into unemployment. And unemployment allows anybody who loses their job for anything other than willful misconduct. Again, this is sort of the global rule, to file for and get unemployment benefits. And the amount of benefits you're entitled to depends on how much compensation you earned in your base year, which is it's a complicated calculus we don't need to get into right now, but that's sort of unemployment. Now, when the COVID crisis happened and Congress passed the CARES Act, one of the things it did in the CARES Act is it said that if there's any unemployment filings that exist as of the date of this act, or that are approved up until July 31 of 2020, if somebody has lost their job or become somehow furloughed or otherwise unemployed because of a COVID-related reason, in addition to whatever they're getting under their state benefits, the federal government is giving them an extra $600 a week. That's been in place now since April 1st, and I know that people have been getting it. But that's people who are unemployed and
Okay.
their only income is what they're getting under state unemployment or the PUA plus the extra $600 a week federal kicker under the CARES Act. Now, workers' comp is if you're an employee but you're injured in the course and scope of your duties. Pennsylvania created a system in the 1930s that said employees generally are no longer allowed to sue their employers for personal injuries. Instead, we're going to create this workers' compensation system where normally if there's a car collision case, you have to prove that the other side, the individual who caused the collision, was negligent. They did something wrong. They were careless. They breached the duty. The General Assembly, in creating the Workers' Comp Act, said because we're taking an employee's general right to sue their employer away, we're going to, on the other hand, eliminate the employee's requirement to prove that the employer was somehow negligent. The only thing the employee has to prove to get workers' comp benefits is that they were injured in the course and scope of their duties. That's it. If they can do that, they're entitled to benefits. And comp benefits are medical bills plus wage loss if the injury sustained has prevented the individual from working. So again, in this context, when we're talking about COVID, to sort of tie it all together, if someone says, I think I contracted COVID because my employer wasn't wiping the stuff down or wasn't providing PPE, personal protective gear, then and they contracted COVID, they have a right to file a comp claim and a workers' comp claim and argue that I contracted this in the course and scope of my employment, and therefore I'm entitled to medical bills and wage loss. Now, again, I don't know if that individual is going to be factually be able to prove that. I mean, how can you prove you got it from your employer as opposed to going to the grocery store? But you have the right to file a claim and test it if, the facts are there.
Yeah, we're going to have to wait and see, I guess. And we'll be sitting around this time next year with a lot more, I guess there will be case law out there from people that go through it at this point in time. But I guess the moral of the story, it sounds like there's a procedural avenue if you believe you contracted COVID-19 at the workplace.
There is.
So now back to being from the role of the employer. Can I, as the employer, postpone a new hire's start date or withdraw a job offer because that individual's at high risk for COVID-19? By high risk, I mean maybe they're a pregnant female employee or a 65-year-old or up employee, somebody like that I'm aware based on the science that's out there that they're high risk for COVID-19. So I just don't want to hire them anymore. Can I do that?
No. That's a pretty definite answer. Again, things like age.
It doesn't depend.
It doesn't depend. No, I'm going to actually give you a straight out answer this time. No, things like age and gender, pregnancy status, those things are protected categories and classes under the law, federal and state law.
So it's really a civil rights thing.
Well, yeah, I mean, Title VII, which is the federal law, says that an employer can't make hiring decisions based on a person's age, gender, national origin, religion, disability, sex, pregnancy status. The the Age Discrimination and Employment Act says that an employer can't take age into account, and older workers are defined under the law as anybody 40 years old or above. So again, as an employer, I try to take this out of the COVID context, because in some ways COVID has changed a lot, but in other ways it doesn't change anything. I mean, if an employer comes to me and says, do I have the right to withdraw and offer employment for this 65-year-old person because I think they're probably going to retire in 2 years and I don't want to have to deal with this again, I would say no, because you can't make that decision based on their age. That's illegal discrimination. So just, to carry the analogy forward, an employer can't say, well, I want to withdraw this offer that I made to the 65-year-old because I'm afraid this person is going to come down with COVID, or, it could be, the best intentions in the world. The employer could say, I don't want to put this person in danger, but that's not the employer's job, right?
Right.
The employer is either going to offer a job or they're not going to offer a
Right,
job.
because in this scenario, they've already offered the job, right?
Correct. So if they're going to withdraw a job offer, that is pretty textbook adverse employment action based on a protected category or class. I think the employer's got a problem there.
So now I've gone through with it. I'm the employer again, and now it's post offer. Am I able to take an applicant's temperature as part of a post offer pre-employment medical exam? I'm kind of picturing the way in professional sports they'll be pending a physical. Your trade's complete. That's sort of the question. Am I able to screen them before I guess the employment is undertaken?
You are. There's different rules for pre-offer medical exams and post-offer medical exams under the Americans with Disabilities Act. So an employer can make an offer of employment contingent upon the passage of a fitness for duty exam, essentially. And these days, screening an employee, and I'm talking about screening an employee by taking their temperature, which is non-invasive, asking them screening questions generally about their contact or exposure to COVID, I don't see any reason why that wouldn't be permissible. Now, I don't think that an employer can start administering COVID tests in the office. That's a little far afield. But general screening questionnaires, I think that's perfectly acceptable.
Okay. Now to take it another step further, we finally get to the finish line, so to speak, and now there's a vaccine available. Am I, as the employer, now able to require that my employees get vaccinated? I mean, it's kind of, in certain conversations, it sounds like an absurd question, but if it's available, can I have my employees get that and say it's a requirement of your employment?
I think that when we get to the point of having a vaccination, this is going to be a fertile ground for a lot of legal battles, because the answer is, I don't know that anybody knows the answer. I mean, right now, the issue is, let's draw a parallel. If you work for a hospital, right, regardless of your job, you're a maintenance man, you're a doctor, you're a nurse, more likely than not, if not for sure, the hospital would require you every year to get a flu vaccination. Right?
Yeah.
Just because they have patients who are compromised. And
yeah, you're around it. You're going to be exposed to a certain amount of it. Get the flu shot.
Exactly. So if we get a vaccine for COVID, I absolutely 100% guarantee you every hospital and healthcare provider is going to make all of their employees get mandatory COVID vaccinations. And I don't see any reason why that would not be legal. If we get a vaccination, I for sure would guarantee that every public school district is going to require all of their employees and all of their students to have COVID vaccinations, right? So those I think are the easy ones. Then we devolve down into the private employers. Well, can your private employer right now make an employee get a flu shot? I think, again, it depends. What types of private employer are you?
Right.
Are you someone who has 25 employees, but they all work remotely from home with no interaction? I don't know that there's a compelling reason from a health and safety perspective to force those individuals to get any vaccinations. But if you are a employer that, runs a Target or a Dick's Sporting Goods, and you're interacting with members of the public, including children and older individuals, maybe that makes more sense. Or you work at a grocery store, or something where you're handling food products. I could see a compelling public health need to require all employees to get COVID vaccinations. So I think it's going to be sort of on a case by case basis,
Yeah.
but there's going to be a lot of fighting about it.
Yeah, I imagine also you kind of moved on to the private employer aspect, but I would imagine one of the battlegrounds will be there are a lot of families and parents that are anti-vaccinations, or they would prefer not to. So I would imagine there might be some pushback on the school level as well.
Yeah, there's going to be pushback from those individuals. There's also going to be a lot of interplay with claims that forcing vaccinations may be against some individuals' religious beliefs.
Right.
And obviously, there's a Title VII also prohibits employers from taking adverse actions on the basis of employees' religious beliefs. And there's a lot of intersecting with public laws involving the First Amendment. So it's a complicated area and a complicated question. It's going to take a lot of cases and a lot of court energy, I think, to disentangle and get some clear guidance on. But that's going to be a fight when those vaccines start coming down.
So this is more of an HR related question, but let's say an employee is concerned with their coworker and other employees' presence in the office because the employee is exhibiting COVID-19 symptoms. So, I mean, the classic, guy or girl in the desk next to you is hacking, coughing all day, and in past years you might have just said, now I'm going to get sick, or the whole spreading it around the office, that's if it was frowned upon before, it is more than ever now. So what do I do what if I'm concerned with my coworker who seems sick?
Well, if you're an employee who's concerned about a coworker, I think you need to report it up the chain to a supervisor.
Okay.
And I don't think employees should be taking unilateral action against their coworkers. There's a reason that there's levels of management in private employers. But if the employer has actual or constructive knowledge that somebody in the workplace is actively exhibiting symptoms potentially of COVID, I think the employer in this day and age, as we're still dealing with this, will be well within its rights to tell the employee, you need to leave, go home, and you need to get a doctor's note clearing you to return to work.
A physician's note, yeah.
Yep.
Okay, yep. I mean, that's simple enough. So can employers administer COVID-19 tests before permitting employees to enter the physical workplace? So this is I think you touched on this before. I'm talking about an actual test, not taking a temperature, not doing like a screening. We can talk about that a little bit too, like a screening questionnaire. Because I know I've participated in many of them, but nobody's actually given me a COVID test to do anything.
I hope not. Screening questionnaires are completely fine. I mean, you're asking somebody questions about symptoms and whether they've been tested, whether they're awaiting test results, whether anybody in their household's been tested, or whether they're treating anybody, or whether rather they have anybody in their household who's been treated for COVID. That's all fair game these days, because there's a public health reason for wanting to make sure we keep symptomatic or potentially contact positive individuals away from others. But again, my advice to employers: if you're not a doctor, you're not a doctor.
Right.
No private employers should be administering COVID tests. I mean, if you ever had or seen a COVID test, it's a Q-tip that's about this big that they shove up your nasal cavity. It's not like taking somebody's temperature with a thermal thermometer that's
right.
contactless. That's fairly invasive.
Right.
I think I heard the other day, even the vice president said he got one that was very invasive. So employers should not be administering invasive medical testing to their employees at all, at all. Forget about COVID.
When you put it that way, it's
Um,
a pretty obvious answer.
yeah, I mean, but beyond that, I mean, there's liability issues. I mean, if you're not a doctor, you're not a medical professional, you're not qualified to administer the test in the first place. But so if you do it, you do it wrong. I think that might take you outside of the workers' comp arena. I think if, I as an employer who is not medically trained and has no, practice or experience, intentionally shoves a giant Q-tip up my employee's nose to test them, and I wind up damaging something or creating some sort of significant injuries. My doing that intentionally, I think allows then the employee to sue me civilly outside of the Workers' Comp Act for civil damages, because that's outside the scope of their employment, and I made an intentional decision to do that. So there's liability issues there too, and that may or may not be covered by insurance because it was an intentional act. So it's just a bad idea all around. Employers should say if somebody has symptoms, or if they're suspected of having COVID, or they admit that they have a family member at home who has it, or something of that nature, then the employer should tell the employee to go home and get a doctor's note to be cleared to return to work.
Yeah, I mean, it sounds very logical. Now, I'm going to get dressed up for this next question.
Oh, no. Oh, I thought you were going to rob me.
I still might. So this is my, my mask for around the office. Must employers provide employees with personal protective equipment around the office?
I think the answer is yes. At least in Pennsylvania. There was an order that was handed down by the Pennsylvania Secretary of Health somewhere around mid-April, when some of the counties were starting to move from the red to the yellow phase and things were beginning to reopen. It's a fairly extensive order. And if you read that order, one of the things that the Secretary of Health said that employers who are permitted to operate should be doing is providing masks to their employees, and rearranging the office, or taking any measures necessary to maximize social distancing, and reduce sort of interactions between people, and encouraging telework as much as necessary. Now, as of today, as we talked about before, all the counties in Pennsylvania have moved to green, with the exception of Philadelphia, which is, I guess, lime
Staggered
green,
until July 2nd
semi-green
or something.
Yeah, they're lime green. But so far as I'm aware of that, the Secretary of Health's April order is still in effect, because green doesn't mean all good. Green is still a phase. There's another section after green, which is nothing. So until we get to nothing, we're still in this, public health crisis. And so I think that as of right now, at least in Pennsylvania, non-healthcare workers have an obligation under the Secretary of Health's order to provide personal protective gear. I think healthcare workers and healthcare employers are providing PPE generally to their employees anyway, so I don't think that's an issue. But for private employers, yeah, I think there is an obligation to do that.
So
now, whether it's legally enforceable or not is a different issue.
Okay. Now, speaking of enforcing, what if an employee is provided with PPE, personal protective equipment, masks, gloves, if necessary, and they repeatedly come to work without it? They were given this stuff. Let's just use a mask as an example. So they're given a mask every day. They come in, they throw it in their drawer, or they don't bring it. What do I do as the employer?
Whatever you want to do, up to and including termination. I mean, look, this is no different than any other workplace rule.
So it's really like an at-will circumstance.
It is, and the default rule in Pennsylvania, unless you have a contract or a member of a union, you're an at-will employee, which means you can be fired for good reason, bad reason, or no reason whatsoever, so long as it's not explicitly discriminatory, retaliatory, or otherwise illegal. So an employee does not have a right to not wear a face mask in the workplace if the employer says, thou shalt wear a face mask. Um, you know, so I think that employer be well within their rights of terminating that employee. And I'm fairly confident in that circumstance, if the employee filed for unemployment, he or she probably wouldn't get it. Because, an intentional violation of a workplace rule that you've been told about by your employer and you intentionally refuse to follow constitutes willful misconduct under the unemployment law, which would disqualify an applicant for benefits. So I think, like any other workplace rule, it's either conform or walk.
Yeah, and I think that's especially relevant because you have different individuals have varying degrees of feelings about mask wearing versus not wearing. Obviously, the prudent move is to wear them. But if your employer requires it, that is the rule for the workplace. And so it may not be the hill to die on. If
It's not.
because you're not going to get you're at a high risk of not even getting unemployment after being terminated for what sounds to be a valid reason.
Right. The employer just needs to be careful. Again, one of the blanket and general rules that all employers should follow in any circumstance is treat similarly situated employees the same. Okay. Don't start cherry picking because that's when you have problems. So if this employee refuses over here, refuses to wear her mask, but this employee over here also refuses to wear his mask, and they both have the same job, but she is fired, but he is not, that theoretically could give rise to a gender discrimination claim.
Right. But it wasn't the fact of the mask. Yeah.
Right. What changed there? Well, their gender changed. And if the only thing that you change in that analogy or that formula is somebody's gender, you by definition engage in sex discrimination. So,
right. So on its face, the firing for failure to use the mask I provided you, that may be okay on its face. But if there's another underlying reason that is discriminatory and it's protected class or something like that, you're still run afoul and now you're in trouble.
Right. So to carry this example on, if an employer is going to fire an employee for not wearing a mask, the employer better be sure the employer is firing every employee who refuses to wear a mask.
Right.
Otherwise, we're creating buckets of people. As soon as you start creating buckets, there's other issues pop up.
Right. I hear you. Well, Mike, that's it for my questions. I don't know if you had any parting words, but I appreciate you coming on, and I'd love to have you back, specifically maybe as we get closer to the school year. We'll know a lot more about Southeastern Pennsylvania school districts and how they're going to handle going back to school or virtual school, whatever we're doing, and how things may have evolved from there.
Yeah, definitely. Thank you for having me on. This was fun. Definitely do it again. I would just tell people, look, these laws are new. They can be confusing sometimes. There's a lot of employers that, for example, the school one we talked about. Normally, if you're an employer with 25 employees, you've never been subject to the Family Medical Leave Act, because that only applies to employees with 50 or more. But now with the Family's First Leave provisions, with the emergency sick pay and the school leave pay, that now applies to employees with 500 or less. So now all of a sudden you're subject to part of the FMLA, but not all of the FMLA. So if you've never dealt with it before, you don't know how to deal with it. So you want to make sure that you know which path you're going and not go down the wrong one. So my point is that all these laws can be, and how they intersect with each other, they can be confusing and they can be complicated. So as if you're an employer or a small business out there, don't go it alone. You know, we're here, we can help. We can sort of help, you know, guide you down that path now and then when things change, if they change or if they get better and if they get worse. But, you know, don't, you know, we're here. So I would encourage everybody to reach out and don't go it alone.
Yeah, and how can everybody reach you? I think I said it at the very beginning, but if you made it this far, how can people reach you?
If you've survived it this far, so you can always call us at the office. Our number is 610-565-3700. You can email me directly. It's mdavey, MDAVEY at eckellsparks.com, or just go to our website. Probably the easiest thing to do, www.eckellsparks.com. Find us on there, find Chris and I, and we're here to help.
Mike, I appreciate you coming on, man. Hope you have a nice weekend and happy Friday.
You too. Happy Green Day.
Thanks. You too.